Virtual Lesson 5.1 Principles of International Law. State Sovereignty and International Law. Throughout history, nations that occupied native lands or territory that was claimed or won through political or military means felt entitled to rule those lands as they saw fit. This principle of state sovereignty arose naturally on the basis that no other entity would be in a better position to dictate how a country's affairs are governed than the country itself. With advances in production, communication, and diplomacy, it then made sense to establish international laws to regulate things such as trade and dispute resolution. Such laws were generally not imposed by one country over another, but were mutually agreed upon to make international dealings more efficient. The relatively recent trend toward globalization has made the international community much more interdependent. Although state sovereignty still exists, it may be limited by the fact that any particular nation relies heavily on others, and therefore may be coerced into adopting policies. In Canada, since we are now so dependent upon foreign investment, exporting natural resources, and importing consumer goods, we are very much influenced by international law. Specific needs for international law. In addition to the voluntary agreement among countries to international rules that facilitate beneficial practices, there have also been circumstances arising in recent decades that demanded international rules and cooperation. One example was the atrocities carried out by the Nazi regime during World War II. When the extent of the genocidal practices came to light after the war, the international community felt the need to respond and punish those who were considered to be the most guilty. International cooperation was required to prosecute these people for war crimes at the Nuremberg trials. Technological advances have also created needs for new types of international laws. The launch, control, and use of satellites, spaceflight, and the ability to conduct activities in the far north are now realities that require the balancing of international interests. In 1967, the United States, United Kingdom, and Soviet Union signed the Treaty on Principles Governing the Activities of States in the Exploration and Use of Outer Space, including the Moon and other celestial bodies. And many other countries have signed the treaty since. The main thrust of the treaty is the principle that outer space is to be explored cooperatively for the benefit of all humankind, and that individual countries are not to lay claim to any part of it or use any part of it for military advantage. Canadian sovereignty over the far north has been a hot political issue in recent years. Canada claims territorial rights to the waters surrounding the Canadian Arctic archipelago, as well as the waters as they extend to the North Pole. However, other countries, including the United States and Denmark, suggest that international boundaries in Arctic waters should be defined differently. This is another area that will depend upon international law more and more, as polar ice caps melt, opening up shipping routes, and as technology makes oil extraction in the far north more feasible. Early international law. Early international law had very little to do with the regulation of individual activity. One familiar exception was the prosecution of piracy. Due to the difficulty of controlling piracy on the high seas, it was agreed among nations that those apprehended would be subject to universal jurisdiction, which meant that they could be tried in any country. Early international law primarily dealt with the protection of diplomats, the establishment of borders, and treaties. International law and domestic law. Unlike laws that are passed by one particular government for application in their own domestic jurisdiction, international law does not operate within a formal justice system. Countries are not able to pass legislation that is binding on other countries. There is no overarching judicial system that can be relied upon to settle disputes, and there is no enforcement agency with the unfettered ability to carry out punishments or directives. The international judicial institutions that do exist, such as the International Court of Justice and the International Criminal Court, have limited powers. As opposed to being in a position where they are subject to international laws, countries are encouraged, persuaded, or possibly coerced into agreement through political pressure. A large part of international law is contained in treaties. A nation's participation in a treaty is generally a two-step process. Firstly, a representative must agree in principle to the terms on behalf of their country, and secondly, the terms must be ratified, which means passed by the legislative body of that country. Due to the voluntary nature of such international treaties, sometimes there are gaps in participation which make the operation and enforcement of the treaty challenging. For example, the International Criminal Court, established by the United Nations in 2002, is an important judicial body set up to try individuals for charges of genocide, crimes against humanity, and war crimes. However, a number of powerful countries, including the United States, Russia, and India, did not agree to its terms and are therefore not subject to its decisions. Regulating the international impacts of domestic activities. Extraterritorial legislation. One important function of international law is to regulate extraterritorial legislation passed by one country but affecting the citizens of others. An interesting example of this was the Helms-Burton Act, also known as the Cuban Liberty and Democratic Solidarity Act, passed in the United States in 1996. When Fidel Castro took control of Cuba in 1959, he nationalized property owned by both Cubans and foreigners who were mainly American. This meant that he seized ownership of land and businesses in the name of Cuba without compensating the original owners. The United States responded by imposing trade sanctions against Cuba in 1962. Those of you who have eaten meals in Cuba have probably felt the effects of their limited options for importing food. In the 1990s, the Cuban government attempted to sell or lease some of the nationalized assets to corporations in foreign countries. The United States then responded by passing the Helms-Burton Act, which allowed former owners of the nationalized American assets to sue for any profits earned in dealings with those assets. The legislation also provided for the denial of U.S. visas for executives and majority shareholders of companies deemed to be trafficking in nationalized assets. This created the controversial situation where individuals in Canada, for example, could be sued in U.S. courts for activities that are both conducted outside of the U.S. and considered legal outside of the U.S. The international debate that ensued resulted in the U.S. suspending these provisions of the legislation. Pollution. International law is also required to settle disputes that arise when one country somehow causes physical damage to another country. In these cases, a third party or international tribunal may be called upon to render a binding decision regarding damages. There are two well-known cases that involve Canada. The Trail Smelter case of 1937 was based on a claim by the United States against Canada that stated that a metal processing plant in British Columbia was releasing fumes into the atmosphere that were damaging apple crops in the state of Washington. The tribunal deciding the case ordered Canada to pay damages and to take steps to reduce the emissions. Another interesting case occurred after the Soviet nuclear-powered spy satellite Cosmos 954 crashed in northern Canada. The Soviets were held responsible and ordered to pay compensation to Canada for the cleanup costs. Treaty law. The purpose of treaties. Treaties are agreements made among states for the purpose of regulating many different types of activities, similar to the way legislation regulates activities within a particular state. A treaty may be bilateral between two countries or multilateral among more than two countries, and may be referred to by other terms such as convention, protocol, memorandum of understanding, accord, arrangement, or exchange of notes. The current law governing treaties. The law that governs the operation of a treaty is derived partly from the treaty itself and partly from customary law that was codified in the Vienna Convention on the Law of Treaties, which came into force in 1980. According to customary law, there are 4 stages in the life of an international treaty: negotiation of its terms, signing of an agreement by representatives of the participating states, ratification or formal acceptance by the governments in each country, and implementation in each country. According to the Vienna Convention, treaty negotiations must not involve the threat or use of force in violation of the principles of international law embodied in the Charter of the United Nations. Acceptable negotiation practices were further clarified in 1999 by the UN resolution, Principles and Guidelines for International Negotiations. Canadian law on treaties. In Canada, signed treaties must be ratified by the federal cabinet. In some cases, treaties considered to be highly important are submitted to Parliament for its opinion. The Kyoto Protocol, for example, was put to a vote in Parliament due to its potentially dramatic effects on the economy. At the ratification stage, treaties may be rejected, accepted outright, or accepted with reservations. Reservations are modifications to the country's obligations as defined by the written text of the agreement. Reservations may actually be prohibited by the terms of some agreements if the signers wish them to be immutable. In Canada, the implementation of a signed treaty involves the adoption of its provisions through legislation passed either by the federal or provincial governments, depending on the subject matter. Since it is generally the federal government that negotiates the terms, the risk exists that the provincial governments might view things differently and not ratify the treaty. To avoid this problem and possible international liability, the federal government will generally not agree to any treaty terms until it has assurances from the provinces that they will pass the corresponding legislation required for implementation. In circumstances where some provinces are unwilling to guarantee that they will pass the required implementing legislation, the negotiators may include a federal state clause, which allows for treaty obligations to apply only to the provinces who have agreed to them, and which also allows the federal government to extend the treaty obligations to the other provinces should they later change their position. Solving disputes. Treaties are ongoing agreements that may from time to time result in disputes. Most treaties include provisions for dispute resolution. Typically, disputes arise due to differing interpretations of the text of the treaty itself. International law includes rules for treaty interpretation, many of which have been codified in the Vienna Convention on the Law of Treaties. The main goal of treaty interpretation is to give effect to the intentions of the parties to it. Intentions are generally determined by examining 2 sources of information: evidence of the intentions of the representatives during negotiations, such as transcripts of their discussions, and how the treaty was actually put into practice after implementation. Some treaties include mechanisms for amendment, and some even establish a process of regular review and amendment. This is the case with the United Nations Framework Convention on Climate Change. Treaties that do not include provisions for amendment or termination can be problematic when circumstances change, especially when a great deal of time has passed since the agreement was made. International law allows for parties to escape their treaty obligations if circumstances have changed in a fundamental way that could not have been foreseen at the time the treaty was made. Diplomatic relations. Some important aspects of international law arose not through treaties, but from state customs. One important historic area of customary international law is the protection of diplomats. After the end of the Second World War, it was seen to be more important than ever that international communication and agreement be encouraged. This required active diplomatic missions and embassies to be established around the world. It then became more important than ever that the international law governing diplomats was well understood and reliable. The process requires the safety and security of diplomats so that they will be sent without hesitation. The customary international law regarding the protection of diplomats was codified in the 1961 Vienna Convention on Diplomatic Relations and additional rules have been adopted since due to changing circumstances. Even with the dramatic advances in telecommunication that have occurred in recent decades, face-to-face discussion is still desired when important and possibly sensitive international matters are involved. Diplomatic immunity. The provisions for diplomatic immunity contained in the Vienna Convention state that the person, personal property, and real property of diplomats or diplomatic missions shall be inviolable. Security of the person means that diplomatic agents are not to be physically harmed, detained, or arrested. Security of personal property protects transportable items such as documents, diplomatic bags, mail, shipments, and telecommunication devices. Security of real property means that citizens or agents of the host state may not enter upon the lands or buildings of an embassy without authorization. This special status of diplomats creates the potential for abuses or political tension when one of them misbehaves in the host country. Generally, diplomats are immune to prosecution by the host state, so it is then up to the home country to ensure that justice is served, hopefully to the satisfaction of the host. One example occurred in 2002 when a Russian diplomat was found guilty of involuntary manslaughter in a Russian court after killing an Ottawa woman in a drunk driving accident the year before. Diplomatic asylum. Diplomatic asylum is the protection that embassies can offer individuals who are nationals of other countries. Because of the restriction against entry into diplomatic real property, citizens of the host country or of a different country altogether who fear for their safety can seek refuge there. What to do with the individuals who had sought diplomatic asylum then becomes a matter of negotiation among the host country, the home country of the embassy, and in some cases the home country of the asylum seeker. The rights of territorial or political asylum differ from diplomatic asylum as they are based on a persecuted person entering a different country for protection as opposed to entering upon the grounds of an embassy. One well-known example of political asylum is the recent case of WikiLeaks co-founder Julian Assange. Between 2006 and 2010, WikiLeaks released large amounts of sensitive information about controversial or improper corporate and government action, including vast amounts of evidence of wrongdoing by the U.S. government that had been provided by Private Bradley Manning, now Chelsea Manning. Due to his fears of repercussions from the U.S. government and to controversial criminal charges that had been laid against him in Sweden, Assange sought and was granted political asylum in Ecuador. Consulates. Consulates are institutions set up by a home country in a host country to protect the rights of nationals from the home country. Consulates and their staff are not designated as diplomats and do not enjoy the same benefits and protections provided by embassies. Consulate staff may take on such responsibilities as obtaining legal representation, negotiating with local authorities, and lodging protests if the rights of one of their citizens are being violated. One famous case involved a Canadian consulate in Saudi Arabia which had to negotiate for access to and the eventual release of William Sampson, a Canadian national who had been sentenced to death for his alleged involvement in a number of car bombings.